Lou, thank you very much.
Thank you.
All right, I'm going to go ahead and call up our next panel, Kimberly McCullough, Gail Meyer, and Michael Salvaggio.
Good afternoon, or good morning, Chair Przanski, members of the committee. My name is Kimberly McCullough. I'm here on behalf of the ACLU of Oregon. I want to start out with just a little bit of context, which is that there has been a lot of litigation around the country over the past 10, 15 years regarding the right of individuals of the public to record on-duty law enforcement. And there's a general consensus that has been reached from that litigation, which is that individuals do have a right under the First Amendment to record law enforcement when those officers are engaged in their official duties. The unfortunate situation, however, is that interference with that right to record does happen with a great amount of frequency. It's not every officer. There's, I would say, the majority of officers know that people have the right to record. There are also a lot of different police departments that do a good job of training their officers, but the unfortunate reality is that there still are many officers who do interfere with the right to record. You can just get on YouTube or the internet and do some quick searches, and you'll find many examples of that. Eavesdropping statutes have been one of those methods, along with other different types of charges or just telling people to stop recording. And many of those eavesdropping statutes around the country have actually been struck down. Two very significant statutes being Maryland and Illinois, which were struck down by circuit courts of appeal, federal circuit courts of appeal, as applied to recording of on-duty police. Oregon's law is a little different than some of the other eavesdropping laws in its language, but what it does is it requires an individual to specifically inform all parties to a conversation before they can record that conversation. That language has been interpreted by Oregon courts to mean that someone has to provide unequivocal warning. So that means they have to actually do something to get the officer's attention to inform them that they're recording. And there's a problem with that, and that's this, that people pull out their phone when they see law enforcement engaged in some sort of activity, and they hold up the phone and they start recording. They don't say something when they do that. They don't say, hey, I'm recording. They just hold up their phone. And the reason they do that is because they know they have a right to do that, and because courts around the country have said that they have a right to do that. So people are technically violating Oregon's law, don't even actually realize it. The other reason that it's problematic is because it's not always safe to tell an officer that you're recording them. Say, for example, an officer is engaged in some sort of excessive use of force, or you think they're engaged in an excessive use of force, and you hold up your phone and start recording, and then you say, hey, I'm recording you, you're now drawing the officer's attention to yourself. And so that may not be a safe situation if there's some sort of misconduct occurring. Another situation could be an officer that's not engaged in misconduct. They're doing absolutely what they should be doing, but it's a dangerous situation for them, and they need to be paying attention. And if there's a bunch of people standing around yelling at them about how they're recording, that actually is distracting to the officer. Those officers would frequently hope that people would just stand by quietly while they're engaged in some sort of complicated activity. I'd like to also just point out that eavesdropping statutes were initially enacted around the country in order to protect individuals from other individuals and from the government, but primarily from the government. The eavesdropping statutes actually popped up after the Katz decision, which held that people have a reasonable expectation of privacy, and that that's the standard for searches by government. And that was actually when these laws popped up. And so using them to prosecute people for recording law enforcement really turns the whole purpose on its head, and that's one of the main reasons that courts have given for striking down these laws. So this particular bill is important, and it's not necessarily important because this law is being used all over Oregon a lot to prosecute people. In fact, it has been used in the past, and we haven't gotten very many reports in recent years of its happening, but the fact that it's on the books is having a chilling effect. And I can give you a really tangible example of that. We have a phone application called Mobile Justice that the ACLU of Oregon launched earlier this year or last year. And when we decided to launch that phone application, it basically allows you to record law enforcement, and when you're done recording, it gets uploaded to the ACLU immediately. And I was actually not working for the ACLU when that phone app was being developed, but I was a cooperating attorney. And the advice I gave to the ACLU at that time was, don't include audio because you're putting people in the position of technically violating the law. They're then going to have to face those criminal charges. My feeling is that you could challenge that in court and get it overturned, but the fact that somebody is going to then face those charges it has a chilling effect, and it's something we don't want to put people in that kind of a danger. So the legislature is really in a good position to fix this so that somebody doesn't have to face those criminal charges and go to court to fight it. So this bill was introduced by Representative Frederick. After that point, Representative Barker took a very keen interest in it and worked very closely with us, and we gained a number of about 10 additional sponsors from the House side. We worked a lot to fix up the bill. It wasn't exactly perfect when it was passed over on the House side, but Barker made a commitment to work through it and get everything set out. Basically, it requires a person to be recording openly and in plain view. That way, if the officer actually did look at them, they would see that they were recording. This is intended to prevent surreptitious recording. I would just like to note on the record that we do think that certain surreptitious recordings of law enforcement are constitutionally protected. There are a number of cases exploring that, but because of concerns of members of the House committee and other people who have looked at the bill, we decided to just leave that to the courts to decide on a case-by-case basis. The person also needs to be in a place where they have a right to be. The bill on the House side had that as a public place, but then we discussed it further, and it would mean that somebody in their own home would have a less of a right to record than they would on the sidewalk in front of their home, and that doesn't really make sense. Plus, the courts around the country have really held that this is you have the right when you're somewhere that you have a right to be. There was some concerns that it might make people think that they could interfere with police, so we just added a provision that says that this doesn't authorize you to interfere. It doesn't authorize you to trespass. And then there were some concerns that someone would maybe use like a high-powered boom microphone and be standing somewhere really far away from law enforcement, and maybe they'd technically be openly recording, but the officer wouldn't even be able to see what they were doing. And so that was where the language that the officer be speaking at an audible volume was added. Talking to DOJ and the chiefs of police, the sentence that sort of explains what the exemption is kind of a long run-on sentence, and so it's a little bit difficult to understand. So the wording is just a bit awkward, and so Michael Slauson from DOJ is actually working on some language that we can hopefully get into an amendment that just breaks it down real clear and makes it all just clear to people so that they can interpret it well. So the DOJ and chiefs of police wanted me to communicate as well that they do support the bill as it will be amended, and the substance really won't be any different. So thank you.
All right, thank you. Who's next?
I'll go quick.